Today, we have 10 judicial nominees on today's agenda, and all are ready for vote. Of note, if confirmed, Terry Moore would be the first African-American to serve on the U.S. District Judge for Southern District, Alabama. And if confirmed, James Ho would be the first Asian-American to serve as a U.S. Circuit Judge, Fifth Circuit. The three Circuit Court nominees, one from Nebraska, two Texas, are all exceptionally well qualified to serve as appellate judges. The first, Steve Grasz for 8th Circuit. Like me, Mr. Grasz grew up on a Midwest farm. He is a very experienced, accomplished appellate lawyer in the Omaha office of the law firm Heisch Blackwell. Prior to going into private practice, Mr. Grasz served as a number 2 attorney in the Nebraska Attorney General's office for 12 years. Mr. Grasz has extensive experience before the 8th Circuit, the court to which he is nominated. Mr. Grasz has also briefed 9 cases before the Supreme Court of the U.S. This includes a case Mr. Grasz argued on behalf of his client, the state of Nebraska, regarding Nebraska's ban on partial birth abortion. And this appears to be a driving force for the ABA's head-scratching decision to argue that Mr. Grasz is, quote, not qualified, unquote, to serve as an appellate judge, 8th Circuit. Last week, Senator Feinstein asked that the committee hold over Mr. Graz's nomination for another week so that she could ask the ABA some follow-up questions regarding the rating that he got. As I mentioned last week, I was willing to accommodate the request, but I also want to emphasize that holding over nominees more than a week will continue to be a rare exception. The committee has now received a response from the ABA, so we're ready to proceed with Mr. Graz's nomination. I believe that Senator Sass will speak to the ABA's rating of Mr. Grasz in some detail, but I'll say that we've reviewed all the material we've received from ABA, along with other sources regarding his rating. The committee has also received letters of support from hundreds of people who know Mr. Grasz both personally and professionally. And in all these letters, we haven't heard from any accuser who has said that Mr. Grasz will insert personal bias into his judgment or judging, which is one of the ABA's unverified and unverifiable claims against him. All we have is the ABA's claim that an unspecified number of anonymous accusers believe that Mr. Grasz can't separate his personal preferences from applying the law in the cases that might come before him. And the ABA refuses to tell us the identity of these alleged accusers so we can assess for ourselves whether these accusers are credible or have their own personal biases. The ABA certainly knows that no good judge would ever permit this type of hearsay evidence into the courtroom because it is completely unfair and violates the most basic notions of due process. How can Mr. Grasz respond to vague and anonymous charges when he has no idea who made these charges or even what they specifically charge? Moreover, the testimony of the ABA's evaluators reveals many of Mr. Graz's peers find him courteous and able to set aside his personal views in order to even-handedly apply the law. We certainly saw that in him when he came to testify at his nomination hearings. Indeed, Mr. Grasz was the model of a temperate potential judge at his hearings. The ABA's explanation as to why it credited the views of some anonymous accusers over hundreds of Mr. Graz's peers was not at all satisfactory. I can't trust such a secretive process, especially when the ABA won't even shed any light on whom it spoke with. Given all this, the ABA's not qualified rating of Mr. Graz's appears nothing more than a hit job on an exceptionally well-qualified nominee simply because the nominee is pro-life and conservative. The ABA's politicizing of the evaluation process for Mr. Grasz raises a number of concerns. When the ranking member asked that I hold over Mr. Grasz for another week so that she could ask the ABA some follow-up questions, I mentioned that this indicated to me that she was still seriously considering how she would vote on the nomination. If she's already made up her mind and knew how she intended to vote on the nomination, the extra letters and questions seem like meaningless endeavor and a waste of our time and resources. So I'm curious to see how the minority votes on Mr. Graz's nomination today, if they vote against him for doing his job as Nebraska Attorney General in that office to defend Nebraska's statute related to abortion, then all of this back and forth with the ABA seems to have been pointless. If the minority ultimately votes against Mr. Grasz because of the rating the ABA gave him, then I urge them to consider the ABA ratings for two Fifth Circuit nominees from Texas. Both received well qualified. The ABA had no concern regarding today's two Fifth Circuit nominees. They found that both would be able to act as circuit judges free from bias. Either these ratings matter to the minority or they don't. The next nominee on today's agenda is James Ho for the Fifth Circuit. This week I received a letter from the minority members of this committee asking me to postpone the vote for his nomination because the Department of Justice hasn't provided a legal memo. Mr. Ho wrote in 2002 during his service as a line attorney in the critically important Office of Legal Counsel. The OLC essentially serves as the general counsel to the executive branch. The legal advice that the OLC lawyers provide relate to the most pressing issues facing our nation, including our national security, and the legal advice they provide constitutes some of the crown jewels of executive privilege and attorney-client privilege. Yesterday, I sent the Democrats on the committee a letter explaining my views on this, but I'll mention it here as well. First, Mr. Ho is not at liberty to decide whether or not to disclose the OLC memo. He wrote it for the Department of Justice and the Department decision to share or keep it confidential. And the Department has declined to furnish the memo due to what they say are substantial confidentiality interests. The Department also indicated that it, quote, needs to protect the ability of lawyers within the OLC to engage in candid internal discussion and avoid the chilling deliberations that would result from disclosing such communications outside the department, end of quote. So I agree, this isn't a partisan issue. The committee has respected the department's decision to not disclose OLC memos during both Republican and Democratic administrations. As I said in my letter, I'm concerned that requests for disclosure of OLC memorandum may simply be fishing expeditions. Mr. Ho is a very accomplished attorney who is unquestionably qualified to serve on the Fifth Circuit. He clerked for the judge of the Fifth Circuit and a Supreme Court justice. He served in a highly prestigious office of legal counsel in the Department of Justice as chief counsel to Senator Cornyn on this committee and as Solicitor General of Texas. For the past 7 years, he has been a renowned partner at the law firm Gibson Dunn in Dallas. He will make an excellent addition to the Fifth Circuit. Justice Don Willett is also on today's agenda. He served as a member of the Texas Supreme Court since 2005. He's been reelected twice by large margins before serving Texas Supreme Court. Justice Willett served as Deputy Texas Attorney General for Legal Counsel and as Deputy Assistant Attorney General for the Office of Legal Policy at our own DOJ. He served each of these offices with distinction. So I look forward to supporting all these circuit court nominees and to vote out 7 nominees to the district court. Senator Feinstein.